Welcome back to Between Two FARS. I'm Warnicki Miller here once again with Michael Mark and Robert Tepfer, two of our distinguished procurement law attorneys. And we've been talking a lot about ASBCA litigation. Those are contract claims filed in front of the Armed Services Board of Contract Appeals. Now, one of the first things that the government has to actually do or file in a case like this is called an answer. So we're going to spend today talking about what an answer is and what you need to be doing to prepare to file your answer. Bob, Michael, can you first tell us about the litigation process? What's a complaint? What's an answer?
Well, the complaint is really going to articulate what the initial claim was saying, and it's going to speak in legal terms and that the board would like. One of the things that is a lot of fun to do is when you're setting up the answer in response to that complaint is to have all the witnesses and all the documents that you can think of kind of lined up to get ready, and you need to be able to speak to them. Now you have 30 days as the rule indicates, but those 30 days can be extended when you have a valid basis and you get opposing counsel to agree, and they're seldom going to give you a rough time. But what I think is kind of interesting is when you're doing that answer to the complaint, you're going to have more of those follow-on meetings with folks, figuring out who the players are, what the documents are, what people would testify to, and you're also going to be learning what the other side would have to refute it with. So some of the fun that you can have with this thing is at the same time you're putting together the answer, you can also put together discovery. In fact, you can include them in the same envelope and save some postage. And there's nothing neater than to have a rather well thought out answer with all your responses there, very carefully coordinated, and also have a request for documents and for interrogatories as to what documents would support, what witnesses could testify with regard to any particular statement in the complaint. All in one package. They're going to be very busy campers when they receive that.
And the answer obviously has to follow along with what is in the complaint. So again, you need to specifically address everything that's in that complaint in your answer. And to do that, obviously, as Bob said, you need to have your witnesses lined up and you need to have your documents lined up. And if you do that, then the answer should flow fairly easily. If there are any, I'll call them affirmative defenses or allegations that we have, then we're going to try and bring those out also. So the answer refutes, hopefully refutes what's in the complaint. If you can't refute what's in the complaint, then that's an area that you probably are going to want to talk about settling. And then there's things where in the complaint where we may or may not know what they're talking about, and obviously those are areas where discovery is going to be needed. But for the most part, we ought to know everything that's in that complaint. We ought to have an answer for everything that's in that complaint. So again, sentence by sentence, allegation by allegation, go through it and put out what we believe the right answer is, what the case is all about, and the documentation that we have to support that, and the witnesses that we have to support that. As Bob says, that begins to lay out what your interrogatories are going to look like and who you may or may not want to be deposing.
What happens if you have got a pro se, somebody who is not represented by an attorney? The complaint is not a logical sentence by sentence document. Do you have some tips for how you compile an answer in that situation?
Oh, see that I spoke about the informality of the board, and I actually had a case with pro se that went to hearing. And let me tell you, that is a very painful situation to be in, because consciously or unconsciously, the judge becomes their advocate. Yeah. And it is no fun to stand up in the middle of the hearing and tell the judge that they're totally out in left field and that they don't understand the issues, and that's not going to be. I mean, you do it the best you can. In one case that I had, they actually went so far as to compel us to put on our defense first and let the complainant, who should have the affirmative duty to put up their case first, to refute our answer. Yeah, go figure that one out and get back to me, because it was very, very difficult. I do want to comment on something that Michael said, which I think is very important. He mentioned the affirmative defenses with regard to the answer. And that's critical, because it's no fun to get into the case and not have spoken to those in the pleadings. That can be very, very bad.
Okay, I was wondering if you had gotten a complaint that was garbled from your pro se guy. Did you make a motion based on this Rule 6 requirement for a simple, concise, direct statement of each claim? And if so, was the judge receptive to it?
In the case that I had, and it's been a couple of years ago, I don't remember doing that, but I would always be willing to do that from the standpoint of making a more definite statement, getting him, saying that discovery was virtually impossible, or that a answer was impossible because the allegations weren't clear enough to respond to. And I certainly would do that.
Yeah.
What about oh, sorry, go ahead, Michael.
Yeah, I have not run into that myself. Again, I have far less litigation background at the board than Bob or you do, but I've not run into that. But I would agree, Bob, if the complaint is so garbled that we can't figure out what it means, you've got to file a motion for a more particular complaint. And you're probably going to have to provide what amounts to a brief to say why this thing can't be answered the way it's written.
And perhaps at that point also request to be able to have a generalized denial. I've made a motion like that to the board before. And the board has been receptive if the complaint is very difficult to understand. Any other things you think are important for attorneys or contracting officers to understand about this answer process, the process of providing a very, what I think more formalized documents in this procedure?
In my opinion, the biggest thing is you throw it over the fence after specific instructions and have a meeting so that everybody is lined up, so that later on in the case, it doesn't fall apart when the program engineer doesn't agree with the inspector or anything along that line. They get the dates wrong, they get the documents wrong. You lose all momentum. And if they can, their cumulative knowledge may be able to straighten that thing out, but they need to do that.
Yeah, you need agreement on the answer, because essentially you are pinning the government to what's in that answer. So if there's things in that answer that are not correct or that are wrong, we're not going to look good, and we're really hurting our case. So before we file, we need to make sure one last time with the key players, is everything in here right? Is there something else out there that we need to know about? Have I said it correctly? Because I'm like Bob, I do not want to go into a hearing or deposition and get a totally different story coming out of my client than what I thought when I was in the office. That had happened to me in private practice, not in a board litigation. And it was very embarrassing. And oh, by the way, it was not a pleasant session with the client afterwards.
Yes. So remember, for your answer, don't trust, always verify.
I agree.
Join us again next time between two FARS.